Good day, everyone. We are going to be talking about a litigation hold and what that means, and then we'll cover what you are going to be doing for your assignment. A litigation hold is also known as preservation orders, or could be called a hold order, is a stipulation requiring a company or law firm to preserve all data that may relate to a legal action involving a company. This requirement makes sure that the data in question will be available for the discovery process prior to litigation. Therefore, the company that receives this order has to or must preserve records when it learns of pending or imminent litigation that may be coming, or when litigation is anticipated. So this litigation holds prevents, and here's a word that you may not be familiar with. It's called spoliation, which means destroying or altering or mutilating evidence. So that's spoliation, spoliation, which can be a very negative, sometimes catastrophic event if the firm has destroyed evidence and a litigation hold has been placed. An attorney can issue a litigation hold letter, or a company may issue a hold order internally, or the court may issue a hold order. And this order applies not only to paper documents, but also electronically stored information, which is typically has the acronym ESI, electronically stored information. Now, I found a good article about litigation hold procedures, and I'll share the link with you. But ESI, electronically stored information, can, as I said, include paper copies, documents, but anything stored electronically, including writings, charts, recordings, images, or any data compilations. Now, this can be very challenging for storage administrators because all companies must establish a very solid sound retention policy, and that policy has to be applied to their storage systems. Storage systems with a litigation hold feature can then override the existing retention and deletion rules that have been established, preventing alteration or destruction of the data until the legal action has been resolved. Now, this article actually clearly takes place in Texas, but you'll want to check your own state rules of civil procedures regarding potentially discoverable items, and you'll see a list. And the article goes on to talk about notice of litigation and what happens there, so you can go ahead and read that. And then it also gives litigation hold procedures here. Again, this is very specific to the state of Texas, so let's look at some other documents about litigation holds. Whenever you're looking for some good articles, check out the American Bar Association. Here's one today, Law Practice Today, about litigation holds, best practices for your company. So this discusses what a litigation hold is. So it alerts employees as to the risk the company has and then what they should be holding. So I thought this was a good article about the expectation of a litigation hold, and you might want to read that so you understand better what this is. And what does this mean for the law firm or the attorney or paralegal? Well, when faced with a potential lawsuits, attorneys on both sides have a responsibility to inform clients of the duty to preserve that information, hard copies and electronically stored information. So you want to make sure that your clients do not destroy any evidence as well as the law firm. So failure to preserve this electronically stored information or any of this information can result in sanctions by the court. And as you can imagine, the paralegal is usually the one that manages most of the steps in regards to preserving evidence. So it is something that you really need to be aware of. And I thought I'd show you an example of a legal hold letter. It has the parties here, and then a team of names of the legal team have been charged to manage this situation. And then they go on to discuss what should be suspended for deletion. In other words, you have to preserve this information. So in this case, it's email, word processing, calendars, voice messages, videos, photographs, information on your PDA. It must be preserved so that it can be retrieved at a later time. So that's an example of a litigation hold letter. And then I also thought I would show you just an example of a legal hold checklist that a firm might use when this happens. So you would want to notify whoever you need to notify, issue the pre-litigation hold memo to all involved, issue a destruction hold notice, and then when litigation is filed, you need to file a memorandum of post-litigation filing, check off everything that needs to be preserved, and then confirmations, establish a method of compliance, which is a huge piece of this. And then when everything is finished with litigation, then the litigation hold release. Now, I just Googled litigation holds, and as you can see, there are many articles. I would stay away from Wikipedia and stay with the law schools, American Bar Association, Find Law, any of the legal libraries. So there's some good articles that you can read about litigation holds and what they consist of. So this week you are going to answer your review questions on page 54 of chapter 2. And if you're turning in one sentence answers, that is not going to be enough and you'll be deducted points. You need to have a good paragraph, write in full sentences, no bullets, paragraphs. Cite your sources. Your book is considered a source, and I'd highly encourage you to use an outside source. One that I just showed you is a good one. Single space your paper, Times New Roman, 12-point font, 1-inch margins for all of your work this term. So answer the questions. That's part A. Part B this week, based on what you've learned, you are going to prepare at least 30 questions in preparation for a client interview geared at preparing your client to comply with a litigation hold. So this is geared towards your client. Use case 4 on page 256 of your text. You are the paralegal working for a firm, and we are defending, so we're the defense of Melford Olson Honey Incorporated. So we are representing them, we are the defense. Your client, there's a typo, is being sued for breach of commercial contract, and you are preparing your client to identify and preserve all of the data to remain compliant with federal rules of civil procedure. So you'll need to look at those federal rules of civil procedure. After you've prepared your questions, write a 1-page summary, single spacing, containing your preservation plan with your client. And this, you will need to research preservation plans before you even attempt this paper. You'll need to really read and study and understand preservation plans. And then this should be a 1-page summary, single-spaced, 12-point font, Times New Roman, 1-inch margins. So do your very best on this, and if you have any questions at all, please let me know. And I wanted to show you one last thing that will help you with understanding federal rules of civil procedure. It's Rule 37. This is lawhofstra.edu. And this goes through and explains the federal rules of civil procedure pertaining to spoliation of evidence. And you might want to read this so you understand the rule and exactly what this pertains to. Again, this is law.hofstra, hofstra.edu, and that might help you understand the federal rules as they apply. So I hope this all helps you. Let me know if you have any questions at all, and have a great week, everyone. Thanks.